Today, I'd like to go over the structure of federalism and the powers associated with this term. This is a huge tenet of the Constitution, our federal form of government, and the basic definition is simply a division of power between what the national government can do and what the state government can do. So, I'm going to go over the different types of power that exist. We have done a Venn diagram in class over this, so you might recall that, but let's just review it real quick. So the national government is one of delegated powers. All that means is the Constitution has given the national government powers in a variety of forms. First of all, expressed, implied, and inherent are the terms we're going over, but expressed means that it is written in the Constitution. So in this example, you can turn to Article 1, Section 8 and look at all the types of powers. You can point to that in black and white. The next one is implied powers. This is deducted from the necessary and proper clause listed at the end of Article 1, Section 8. It is nicknamed the elastic clause, and I'll show you that in the next couple of slides. And then the last one is inherent powers. Some governments are so basic that every nation has these, such as citizenship and acquiring new territories and establishing statehood. They are inherent powers. So, expressed, implied, and inherent are types of delegated or given powers to the federal government. Some of these are exclusively federal, meaning only the national government has the power to do those things. So, let's just quickly look at some examples of delegated powers called expressed powers. I've given you some different locations in the Constitution. Article 1, Section 8 lists the powers of Congress. Article 2, you can go over the powers of the executive branch. Article 3 lists powers of the Supreme Court. Article 4, Section 4 will go over interstate relations and what states can do. And Article 6, the supremacy clause, means that the national government is supreme over all things. So these are things specifically listed in the Constitution. Congress has the power to tax, regulate interstate commerce, declare war, borrow and coin money, establish inferior courts, raise and support an army, govern territories and property, establish post offices and postal roads, grant patents and copyrights, fix standard weights and measures. They have the definition for treason, and they also discuss counterfeiting of money. Implied powers is a really huge part of congressional authority today, and this is what the Founding Fathers put in there at the end of Article 1, Section 8 to really meet present day needs. The Constitution is called a living document, and I believe the Constitution has been allowed to live successfully over 200 years because it can meet present day needs through this clause. So implied powers are not expressly stated, but they are reasonably implied through the language of Article 1, Section 8, Clause 18. It gives to Congress all power necessary and proper to running the government. It is nicknamed the elastic clause. This is one of those huge clauses, especially if you're taking the AP test, that you need to know to understand how Congress can justify making certain laws today if they didn't have the authority in the written portion of the Constitution. A great example is Congress has established, laws creating the federal highway system or interstate highway system. We have a NASA program for outer space. I doubt that was in the original wording of the Constitution, so that meets present day needs for space exploration and the regulation of labor management relations in case of a strike, like the Major League Baseball strike many years back when UPS went on strike. Those are examples that you can use for this. The next portion is inherent powers, and like I said, these are powers because the national government is a sovereign state. So examples would be the national government has the right to regulate immigration, to deport aliens, to acquire new territory, to recognize states, and to protect the nation against rebellion. Those are inherently national, and therefore they are in the Constitution to do those things. Now, the Constitution is one of given powers, but it also specifically denies powers to the national government. It's like putting boundaries on and the national government, similar to what a teacher might do to students in a classroom. You give them certain rules. So, in the Constitution, Article 1, Section 9 specifically says what Congress cannot do. And then many of the amendments, specifically 1 through 8, prohibit Congress from doing certain things. So, I also put powers are denied because of the silence of the Constitution. So, because it's not in the Constitution, then it's reserved to the states. So sometimes the national government does not have the authority to do those things. Remember, when we had the Federalist essays and we were looking at that, one of the arguments for the Federalist is it's not going to become too strong a government because the powers are listed in what it can do. They can't do it if it's not in there, and that was a huge argument against the anti-Federalists. So some examples are powers denied: the writ of habeas corpus shall not be suspended. There should be no bill of attainder at ex post facto law. Establishing a public school system is not in the Constitution, therefore that's reserved to the states. Some cases, we looked at U.S. v. Lopez, the Gun-Free School Zones Act of 1990, which exceeded congressional authority to regulate firearms in the school. That was overreaching of Congress on interstate commerce. So sometimes Congress is struck down in their overreaching of establishing different laws. So I just wanted to make sure that you had that example. Now, powers of state governments, I'm going to flip to the other side of federalism. State government power, it says the Constitution reserves power to the states, and this is really through the 10th Amendment. You've got to remember the 10th Amendment because that is the source of all state power. And what it basically says is there are traditional state rights. If it's not delegated to the national government, it is reserved to the states. So I've put together a list of different things: business, marriage, legal practice license, professional licenses, civil laws not involving federal issues, criminal laws not made federal, and education rules. These are things that are traditionally state rights. States also have the right to run elections, and so a lot of the civil rights powers the states were dealing with or have been for a very long time. So I wrote the wording out of the 10th Amendment, which I've just said, but remember the 10th Amendment states have rights too. And sometimes there's a clash of power between federal and state government. So state powers, a lot of times the police power is under the state. So the state power to enact laws promoting health, such as vaccinations, safety, dealing with law enforcement, and moral conduct. So these are things that the state has been given the power to do, and you guys have seen in recent events just how the police protect us from different riots, how you guys are all going to college and you have to get certain vaccinations when you attend school, etc. So state powers also have, I just wanted to make sure that we included these terms: recall, referendum, and initiative process. So a recall vote can be taken. This is a state initiative, and if 20 states do this, voters can remove an elected official from office. So California had one where they tried to recall their governor several years ago. A referendum vote is when voters reject a measure passed by the state legislature. So the legislature has passed a law, they put it to the voters, the referendum vote, the voters reject it, and therefore that is a power that the people have in the state government for a referendum vote. An initiative is just what it says. It's an initiative that permits voters to put legislative matters directly on the ballot. So if the legislature isn't dealing with needs, voters and citizens can bind together, get signatures, and get an issue on the ballot. And normally you need 5 to 15% of the 5 to 15% of signatures based on the number of people who voted in the previous election. So I just wanted to go over those state elections as well. Now, the last part here, powers denied to the states. Just like the federal government, the state governments in Article 1, Section 10 have powers expressly denied. Also, if you look at the Civil War amendments, the 13th, 14th, and 15th, the 13th abolishes slavery. The 14th establishes citizenship requirements, as well as the due process clause against the states. And the 15th just says you can't deny the right to vote based on race. The 19th Amendment gives women the right to vote. The 24th Amendment allows poll taxes. And of course, the 26th Amendment gives 18 to 21-year-olds the right to vote. These are expressly, it says, deny state power. And what I mean by that is these are all voting amendments that say the restrictions that the states used to make their own election laws, and these are federal amendments that have sort of dictated what states need to do concerning elections. So, another one, and an example from Article 1, Section 10, states cannot declare war, they cannot coin money, they cannot grant titles of nobility, they cannot enter into treaties or alliances, they cannot pass a bill of attainder or an ex post facto law. So there are things denied, but the nations really do have obligations to the states. In Article 4, it says that the federal government must guarantee to every state a republican form of government. It has to protect us against invasion and domestic violence, and it has to respect territorial integrity. Um, and also, you can't punish a state by taking away its representation in the Senate. So these are some constitutional obligations that the national government said the states had to do. Now, when we admit new states to the Union, remember I said that Congress has authority to do that. I've just simply listed the process of admission here. We talked about it in class dealing with the territory of Puerto Rico. But the desiring states, such as Puerto Rico, ask Congress for admission. Congress will then pass an enabling act, which is just sort of like a permission slip. It's an act directing the people to frame a proposed state constitution. It's sort of a green light. A convention is held in that state preparing the constitution, and it's put up for popular vote. If the voters approve it, it's submitted to Congress, meaning the Constitution, and Congress considers it. If Congress agrees, it passes, and Congress will issue an act of admission, which is an act creating that new state, and then the president will look at it, assign it, and the new state is entered into the Union. There have been some things where I think it was Arizona that the Constitution had the popular election of judges, and they said that the judicial branch should not be elected because it could sway the judges' decisions on the court. So they had that state take out that portion before they admitted it into into the United States. So sometimes they have them edit the Constitution. So the main people responsible for admitting new states to the Union is Congress. And this was an example of what we had discussed in class. So the last thing is just simply going over some of the court cases that expanded federal power. And really, we talked about the framers anticipated the conflict between national and state power, especially after the failure of the Articles of Confederation. So they put in the very last thing was the Supremacy Clause in Article 6. And what that does is it states the Constitution is the supreme law of the land. That's all the Supremacy Clause is. It just is a reminder to the states that federal law, state law, all of it has to comply with the United States Constitution. That is the final authority of United States power. So the Supreme Court became the arbiter or the referee of what the Constitution means and how it is interpreted. And during the early years, the Supreme Court was led by a great man known as Chief Justice John Marshall, who I think very highly of. But in a series of decisions, he powerfully defended the national supremacy of the newly formed government. The Supreme Court was considered for a long time the weakest branch. Remember, Congress and the presidency sort of vied back and forth for power. But Chief Justice John Marshall, in issuing that first large Supreme Court case where they established judicial review in Marbury v. Madison, that elevated the court to be the final interpreters of what the Constitution means. So we also looked at McCulloch versus Maryland, that was the banking case, and Gibbons versus Ogden, which was a shipping case, and those dealt with implied powers and the interstate commerce clause, respectively. And Marbury v. Madison, of course, is the first case that established judicial review. So if you could just review those court cases, also U.S. v. Lopez and Heart of Atlanta was an example of a civil rights case where Congress used the interstate commerce clause to check the civil rights issue. So I wanted to make sure that you looked at that as well. So I hope this has helped in going over powers of Congress and the federal government and how that differs with state powers on the issue of federalism.